consolidating multiple domain names into a single dispute can be a very efficient and economical way for a trademark owner to tackle cybersquatters. But consolidation is not appropriate in all cases, including the one I'm talking about in this video, in which the panel denied a complaint with respect to 4 of the 12 disputed domain names because it found that they were held by different registrants. Now, I've talked about this issue before, including in episode 9 of my masterclass on domain name disputes, which you can find on YouTube and also on my Gigalaw website. In that video, I talk about the largest complaint that has ever been filed under the UDRP, the Uniform Domain Name Dispute Resolution Policy, which I filed and won in 2009 for a dispute that involved more than 1,500 domain names containing one of my client's trademarks. Now, complaints of that size are incredibly uncommon, and most UDRP disputes involve just a single domain name. As I reported in a recent issue of Gigalaw's Domain Dispute Digest, the largest recent UDRP case in the past quarter involved 154 domain names, which was filed by WhatsApp. And the next largest included about 80 domain names and was filed by Transamerica. But even cases of these sizes are outliers because the average number of domain names per case at WIPO, which is the largest provider of UDRP services, was only 1.71 in 2021 and has only exceeded an average of two domain names per case 7 times since the first UDRP decision was issued in 1999. In any event, the case I'm discussing here included, as I said earlier, 12 domain names. The UDRP complaint was filed at WIPO by 2 companies known as Bitrise that are part of a common corporate group founded in 2014. The decision describes the Bitrise companies as the owners and operators as a software as a service platform used to build, develop, and maintain mobile applications. The decision says that the Bitrise companies assist their customers with more than 2 million software builds per month, including in the financial technology sector, and that its business has received significant press coverage.
Bitrise allows us to deploy faster, more frequently, and with confidence, and our apps perform better than ever before. Thanks to Bitrise, I'm able to spend time doing what I love, building better apps, faster.
According to the UDRP decision, the Bitrise companies own at least 2 trademark registrations for the word Bitrise, one in the European Union and the other in the United States, and they use the domain name bitrise.io, which was created in 2014. .io, by the way, is the CCTLD, or country code top-level domain, for the British Indian Ocean territories, and it is now being pitched as a domain name for tech websites, given that IO is an abbreviation of the industry term input-output. Now, the Bitrise case involving 12 domain names was not the company's first time filing a UDRP complaint. It looks like Bitrise has filed 3 previous UDRP complaints at WIPO starting in 2019, each of which included a single domain name, and each of which, by the way, they won. Interestingly, this case appears to have originally included perhaps 20 domain names, because the decision says that the proceeding was suspended to pursue settlement discussions and dismissed regarding 8 of the domain names. The 12 remaining domain names in the case each included the Bitrise trademark, sometimes alone and sometimes in connection with one or more other words, such as wallet or token, in 5 different TLDs: .com, .org, .app, .site, and .finance. The domain names were being used in a variety of different manners, as you can see in some of the screenshots I captured shortly after the UDRP decision was published. Now, substantively, the Bitrise case was not complicated, but procedurally, it addressed the important issue of consolidation and resulted in an unusual split decision. So what exactly is the issue? It all relates to one sentence in the UDRP rules, in paragraph 3C, which says that a UDRP complaint may relate to more than one domain name, provided that the domain names are registered by the same domain name holder. Now, in cases where the WHOIS records identify the registrant of multiple domain names as the same person or entity, this is a non-issue. But increasingly, Cybersquatters use aliases to hide their true identities, so simply comparing registrant names is not always the only examination to be made. And as a result, the WIPO overview says that panels typically examine two factors in deciding whether multiple domain names may be consolidated in a single case. One, whether the domain names or corresponding websites are subject to common control. And two, whether consolidation would be fair and equitable to all parties. In the Bitrise case, the panel said that 5 of the domain names were all registered to a single entity identified as Bitrise Network. So obviously it was appropriate to include all of those in one complaint. And the panel said that 3 other domain names were held by 2 different registrants and that those 3 domain names had all been used in connection with websites for something called the Bitrise token. And as a result, the panel said it was persuaded that all 8 of the domain names were under common control, and that it saw no reason why consolidation would be unfair or inequitable. But the panel reached a different conclusion with respect to the other 4 domain names. And here's what the decision says. It is true that all 12 domain names were registered within a relatively short period of 4 months, and that these other 4 disputed domain names incorporate the same trademark as the first 8, plus another word in 2 cases. However, the available data regarding the other 4 disputed domain names, including their registration details and the uses to which they are put, indicates that they may well be opportunistic registrations by different persons acting independently of each other. Moreover, 2 of these registrants sent informal responses to notices received from the center in the course of this proceeding, while another has been a respondent in multiple proceedings under the policy, but none of them involved any of the other named registrants in this dispute. In these circumstances, the panel is not satisfied that on the balance of probabilities, these 4 domain names are under common control with the first 8. So as a result, the panel went on to issue a decision on the substantive issues of the UDRP's 3-part test for the 8 consolidated domain names, which it ordered transferred to the complainant Bitrise. But it denied the complaint with respect to the other 4 domain names, although the panel did say that its decision was without prejudice to the possibility of refiling complaints for those 4 domain names. So what's the lesson here? Pretty simply, that UDRP panels will not always accept a trademark owner's request to consolidate multiple domain names in a single proceeding. That's why I often recommend to my clients that filing multiple complaints, sometimes simultaneously, is the better approach if common control among multiple domain name holders cannot be established. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other internet legal issues. Thanks for watching, and see you next time online.